Question 1. A pharmacist reviews a collaborative practice agreement, CPA, with a physician. Which activity is most consistent with a pharmacist authority under a CPA? Option A. Adjusting the dose of an existing antihypertensive within a protocol established by the collaborating physician. Option B. Independently diagnosing hypertension and initiating a new drug class without physician oversight. Option C. Prescribing a Schedule II controlled substance without patient-specific prescriber involvement. The correct answer is A. Adjusting the dose of an existing antihypertensive within a protocol established by the collaborating physician. Here's why. The Model Act defines collaborative pharmacy practice as occurring under a written protocol authorized by a practitioner within whose scope it is to prescribe. Adjusting an existing drug dose within a physician-established protocol is the paradigm of lawful CPA authority. The pharmacist acts within defined parameters rather than initiating independent diagnoses. Option B is wrong because Option B describes independent diagnosis and drug initiation. Activities requiring prescriptive authority, the CPA does not confer. The Model Act requires all CPA activity to occur within the written protocol established by the collaborating practitioner. Option C is wrong because Option C describes Schedule II, prescribing without prescriber involvement. Under federal regulations, only DEA registered practitioners with prescriptive authority may issue Schedule II prescriptions. A CPA does not confer Schedule II prescribing authority. So remember, pharmacists execute within the protocol. They don't make the diagnosis. Question 2. A pharmacist dispenses a new prescription to a Medicaid patient under OBRA 90. Which statement most accurately describes the counseling obligation? Option A. The pharmacist or designated representative must make an offer to counsel. If declined, the refusal should be documented in accordance with OBRA 90's implementation through state Medicaid plans and board rules. Option B. OBRA 90 requires the counseling offer only when prospective DUR identifies a drug interaction, therapeutic duplication, or dosing concern. For prescriptions with no flagged clinical issues, the proactive offer requirement is waived and patient-initiated contact is sufficient. Option C, OBRA 90 requires only the licensed pharmacist personally to make and document the counseling offer. Pharmacy technicians or interns may gather patient information but are not authorized to substitute for the pharmacist in making or recording the proactive offer. The correct answer is A. The pharmacist or designated representative must make an offer to counsel. If declined, the refusal should be documented in accordance with OBRA 90's implementation through state Medicaid plans and board rules. Here's why. Federal law requires that the pharmacist or designated representative offer to discuss with each Medicaid patient receiving a new prescription the matters enumerated in the statute. The offer must be made proactively. If declined, the refusal should be documented in accordance with OBRA 90's implementation through state Medicaid plans and board rules. The law does not wait for the patient to initiate. Option B is wrong because Option B incorrectly ties the proactive offer to DUR findings. OBRA 90 requires the pharmacist or designated representative to proactively offer counseling before every new Medicaid prescription, regardless of whether DUR identified any concern. Both obligations apply independently to each new prescription. Option C is wrong because Option C overstates who must make the offer. OBRA 90 explicitly permits the pharmacist or designated representative to make the counseling offer. A qualified designated representative may offer counseling on the pharmacist's behalf. The law does not require the pharmacist to personally deliver the offer for every prescription, so remember, OBRA 90 requires an offer to counsel plus documented refusal. A written guide alone doesn't cut it. Question 3. A pharmacy technician candidate has completed an ASHP and ACPE accredited training program. Under the NABP Model Act and Uniform State Law Principles, what must be completed before licensure as a certified pharmacy technician, CPHT? Option A. Hold an active pharmacist intern license for at least 6 months. Option B. Obtain a personal DEA registration number as a prerequisite for handling controlled substances. Option C. Pass a board-approved technician certification examination, such as the PTCE or XCPT. The correct answer is C. Pass a board-approved technician certification examination, such as the PTCE or XCPT. Here's why. The NABP Model Act requires candidates for CPHT licensure to pass a board-approved technician certification examination, the PTCE, PTCB, or XCPT, NHA. Program completion satisfies the education requirement but does not itself confer licensure. Option A is wrong because Option A describes the pharmacist intern license, a separate credential for pharmacy students pursuing pharmacist licensure. Pharmacy technicians do not hold pharmacist intern licenses. The two licensure pathways are entirely distinct under the Model Act. Option B is wrong because Option B describes a DEA registration number. Pharmacy technicians do not obtain individual DEA registrations. The pharmacy's DEA registration covers all authorized personnel within that registered location. So remember, CPHT licensure requires a board-approved certification exam, not just training hours. Question 4. A pharmacist declines to dispense a valid mifepristone prescription, citing personal moral objections. Which statement most accurately describes the pharmacist's obligations under the NABP Model, State Pharmacy Act, and Uniform State Law Principles? Option A. While no federal law mandates dispensing, a pharmacist who refuses on moral grounds must arrange transfer to a willing pharmacy within 4 to 8 hours and document the patient's access to care. If no alternative is secured within that window, the pharmacist's obligation to dispense is reinstated. Option B. While no federal law mandates dispensing, under Model Act principles and common state board policies, a pharmacist who refuses on moral grounds is still expected to ensure continuity of care, typically by arranging a transfer or effective referral. Option C. Because no federal statute mandates dispensing against conscience, a pharmacist who refuses on moral grounds has fulfilled all professional obligations upon refusal. The continuity of care duty under the Model Act applies only to clinical refusals based on safety concerns, not conscience-based refusals. The correct answer is B. While no federal law mandates dispensing, under Model Act principles and common state board policies, a pharmacist who refuses on moral grounds is still expected to ensure continuity of care, typically by arranging a transfer or effective referral. Here's why. No federal statute contains a universal mandate to dispense nor an unlimited refusal right without patient recourse. Under Model Act principles and common state board policies, a pharmacist who refuses to dispense on moral grounds is still expected to ensure continuity of care, typically by arranging a transfer or effective referral. Option A is wrong because Option A overstates the continuity obligation by imposing a specific 48-hour transfer deadline that no Model Act provision or state board policy establishes. The obligation is to ensure the patient has a path to care, not to complete a transfer within a defined window before a dispensing mandate reinstates. Option C is wrong because Option C correctly notes no federal law mandates dispensing but is wrong about what follows. Model Act principles require ensuring continuity of care regardless of the reason for refusal. The Model Act does not distinguish between clinical and conscience-based refusals when it comes to the obligation to facilitate the patient's access to care. So remember, a pharmacist can decline to dispense, but they can never abandon the patient, refer, or transfer. Question 5. A pharmacy has 3 pharmacists and 12 technicians on shift. 2 pharmacists take simultaneous meal breaks, leaving 1 pharmacist actively supervising all 12 technicians. Which scenario most likely represents a compliance concern? Option A. 1 pharmacist actively supervising all 12 technicians, while the other 2 are simultaneously unavailable. Option B. 2 pharmacists supervising 8 technicians, 4-to-1 ratio per pharmacist, both present. Option C. 3 pharmacists supervising 9 technicians, 3-to-1 ratio per pharmacist, all present. The correct answer is A. 1 pharmacist actively supervising all 12 technicians, while the other 2 are simultaneously unavailable. Here's why. The NABP Model Act and uniform state law principles require adequate pharmacist supervision of technicians. The critical deficiency in Option B is not merely a ratio. It is that 1 pharmacist has become solely responsible for all 12 technicians simultaneously, far exceeding what any single pharmacist can adequately supervise. Option B is wrong because Option B describes 2 pharmacists overseeing 8 technicians. Both supervisors are present and the oversight burden is shared. The key distinction from Option C is that all designated supervisors are available and active. Option C is wrong because Option C describes 3 actively available pharmacists, each overseeing 3 technicians. A well-managed supervision structure with all supervisors present and engaged. No compliance concern arises. So remember, only count the pharmacists who are physically present and available. Lunching pharmacists don't count. Question 6. Under the NABP Model Act and uniform state law principles, which individual qualifies as pharmacist-in-charge, PIC? Option A. Any pharmacist currently employed by the pharmacy, because the Model Act requires only active pharmacist licensure for PIC eligibility. There is no written designation requirement and no minimum hours standard, so part-time employment does not disqualify a pharmacist from the PIC role. Option B. The pharmacy owner, provided they hold a board-issued pharmacy manager certificate and complete a DEA-approved controlled substance management course. Non-pharmacist owners may serve as PIC under a limited exemption for independently owned community pharmacies. Option C. A licensed pharmacist who is designated in writing and accepts responsibility for the pharmacy's compliance with all applicable laws and regulations. The correct answer is C. A licensed pharmacist who is designated in writing and accepts responsibility for the pharmacy's compliance with all applicable laws and regulations. Here's why. Under the NABP Model Act, the PIC must be a licensed pharmacist who formally accepts, in writing, legal and professional responsibility for the pharmacy's compliance. The role requires meaningful oversight, not merely nominal designation. Option A is wrong because Option A incorrectly eliminates the written designation requirement and overlooks the meaningful oversight standard. The Model Act requires formal written acceptance of the PIC designation. A pharmacist working only 2 hours per week cannot exercise the ongoing supervisory oversight the role demands, regardless of license status. Option B is wrong because Option B incorrectly allows a non-pharmacist to serve as PIC. The Model Act expressly requires the PIC to hold a current pharmacist license. Business ownership and management certifications are separate from pharmacist licensure. No exemption permits a non-pharmacist to hold the PIC designation regardless of training completed. So remember, the PIC must be a licensed pharmacist who formally accepts responsibility in writing. Owners and techs cannot serve. Question 7. A patient's metoprolol succinate has no remaining refills and the prescriber is unreachable. The patient is about to run out. What is the most appropriate action under the NABP Model Act and most state pharmacy practice acts? Option A, dispense a 30-day supply of metoprolol succinate documented as an emergency refill because the patient's cardiac history satisfies the Model Act's emergency dispensing threshold and a 30-day quantity ensures adequate bridge while the prescriber is contacted. Option B, refuse to dispense any supply until the pharmacist receives written or electronic confirmation from the prescriber's office because the Model Act's Emergency Dispensing Authority requires documented verification of prescriber unavailability through official office contact before the pharmacist may act. Option C, dispense a limited emergency supply sufficient to last until the prescriber can be contacted. Document the emergency dispensing and notify the prescriber as soon as practical. The correct answer is C. Dispense a limited emergency supply sufficient to last until the prescriber can be contacted, document the emergency dispensing, and notify the prescriber as soon as practical. Here's why. The Model Act, a state law provision, authorizes emergency dispensing of non-controlled medications when the prescriber is unavailable and withholding the drug would endanger the patient. Federal law does not govern emergency refills of non-controlled medications. This authority derives entirely from state law. Abrupt metoprolol discontinuation carries cardiovascular risk. Documentation and prescriber notification are required. Option A is wrong because Option A authorizes a 30-day emergency supply. The Model Act's emergency dispensing provision is designed as a bridge. It authorizes only a limited supply sufficient until the prescriber can be reached, typically a few days, not a full 30-day supply that eliminates urgency to follow up with the prescriber. Option B is wrong because Option B adds a written confirmation prerequisite that the Model Act does not require. Emergency dispensing authority is triggered by the pharmacist's reasonable clinical judgment that withholding the drug endangers the patient. A good faith effort to contact the prescriber, combined with inability to reach them, is sufficient. A formal unavailability certification is not required. So remember, a bridge supply is fine for non-controlled medications when the prescriber is unreachable. Document and notify promptly. Question 8. A pharmacist fills an oxycodone prescription despite multiple red flags. Patient drove over an hour, paid cash, and the quantity was unusually high. The pharmacist dispenses without question. Under federal law, which doctrine holds the pharmacist accountable? Option A. the pharmacy's duty of care under state tort negligence principles, which independently assigns liability to pharmacists who dispense controlled substances to patients displaying drug-seeking behaviors without conducting adequate clinical screening of the prescription. Option B, the prospective DUR obligation under OBRA 90, which requires pharmacists to screen new prescriptions for drug interactions, dosing errors, and clinical abuse patterns before dispensing, creating liability when obvious red flags are ignored during the pre-dispensing review. Option C, corresponding responsibility. The pharmacist shares legal accountability with the prescriber to ensure a controlled substance prescription serves a legitimate medical purpose. The correct answer is C, corresponding responsibility. The pharmacist shares legal accountability with the prescriber to ensure a controlled substance prescription serves a legitimate medical purpose. Here's why. Federal regulations establishes corresponding responsibility. Both the prescriber who issues and the pharmacist who fills a controlled substance prescription share legal accountability for ensuring the prescription was issued for a legitimate medical purpose. A pharmacist who ignores obvious red flags and dispenses may be prosecuted under the CSA. Option A is wrong because Option A identifies a state tort liability rather than the controlling federal regulatory doctrine. State negligence law does impose duties, but the specific federal doctrine assigning shared accountability between pharmacist and prescriber for controlled substance prescription legitimacy is corresponding responsibility under federal regulations, not common law negligence. Option B is wrong because Option B describes OBRA 90's prospective DUR obligation, which is real but distinct. While DUR requires screening for abuse patterns, the specific federal doctrine assigning joint accountability between pharmacist and prescriber for controlled substance prescription legitimacy is corresponding responsibility under federal regulations. The two obligations overlap but are separate legal frameworks. So remember, the pharmacist shares legal accountability with the prescriber for every controlled substance prescription dispensed. Question 9. A pharmacist provides drug therapy management for diabetes patients under a CPA. Which action would exceed the pharmacist's lawful scope under the NABP Model Act and uniform state law principles? Option A, initiating a new medication class not specified in the CPA without physician approval. Option B, ordering and reviewing hemoglobin A1C laboratory results, because Laboratory Ordering Authority under the Model Act requires prescribing level licensure that cannot be conferred through a CPA regardless of the scope language the parties negotiate. Option C, adjusting insulin doses based on the patient's blood glucose logs within the CPA's specified protocol ranges, because insulin therapy modifications involve therapeutic judgment that the Model Act reserves exclusively for prescribers and cannot be delegated through any CPA. The correct answer is A, initiating a new medication class not specified in the CPA without physician approval. Here's why. A CPA defines the outer boundary of the pharmacist's delegated authority. Ordering labs and adjusting insulin within established protocol limits are squarely within drug therapy management scope. Initiating a new drug class the CPA does not authorize requires protocol amendment and physician approval. Acting outside the written scope constitutes unauthorized prescribing. Option B is wrong because Option B incorrectly restricts laboratory ordering to prescribers. Model Act Section 6 permits CPAs to include laboratory ordering and interpretation as delegated drug therapy management functions. Ordering A1C results to monitor diabetes management is a standard and permissible CPA function. Option C is wrong because option C incorrectly states insulin dose adjustment cannot be delegated. The Model Act's drug therapy management provisions explicitly permit CPAs to authorize pharmacists to adjust medication doses within defined protocols. Dose adjustment within established CPA parameters is paradigmatic CPA activity. The limit is on acting outside those parameters without prescriber authorization. So remember, a CPA lets you adjust existing therapy. You cannot add a new drug class without physician approval or a protocol amendment. Question 10. A pharmacy student on an APE wants to counsel patients and verify prescriptions under pharmacist supervision under the NABP Model Act and uniform state law principles. What credential authorizes this? Option A. A pharmacy intern license issued by the State Board of Pharmacy. Option B. A NAPLEX candidate identification number, which permits supervised dispensing during the final year of school. Option C. The student's pharmacy school enrollment confirmation, which implicitly authorizes supervised practice. The correct answer is A. A pharmacy intern license issued by the State Board of Pharmacy. Here's why. The NABP Model Act requires pharmacy students in experiential education, including APPEs, to hold a pharmacy intern license issued by the State Board of Pharmacy. This license authorizes the intern to perform acts constituting the practice of pharmacy under direct pharmacist supervision. Enrollment confirmation and NAPLEX numbers are administrative documents that confer no practice authority. Option B is wrong because option B incorrectly describes the NAPLEX candidate number. The NAPLEX is a licensure examination. A candidate number is an examination administration tool, not a practice authorization. A candidate has not yet received a pharmacist license and cannot practice under an examination number. Option C is wrong because option C incorrectly treats enrollment confirmation as a practice authorization. Under the Model Act, only the State Board has authority to license individuals to practice pharmacy. School enrollment is not a licensure document and confers no authority for controlled substance handling, prescription verification, or patient counseling. So remember, a board-issued pharmacy intern license is the credential that authorizes APPE practice. Enrollment letters don't count. Question 11. Under the NABP Model Act and uniform state law principles, which of the following most clearly falls within the practice of pharmacy? Option A. A nurse administering a medication from a patient-specific cart in a hospital. Option B. A pharmacist reviewing a patient's regimen and identifying a clinically significant drug-drug interaction. Option C. A pharmacy technician entering prescription data into the dispensing system before pharmacist verification. The correct answer is B. A pharmacist reviewing a patient's regimen and identifying a clinically significant drug-drug interaction. Here's why. The NABP Model Act defines the practice of pharmacy to include drug therapy evaluation, clinical decision-making, and identification of drug-related problems. Identifying a clinically significant drug interaction is precisely the cognitive patient care activity the Model Act places within the pharmacist's exclusive scope. Option A is wrong because Option A describes nursing medication administration, a nursing scope activity governed by nurse practice law, not pharmacy law. The practice of pharmacy involves drug therapy evaluation and dispensing decision-making, not bedside administration by another licensed professional. Option C is wrong because Option C describes a technician support function. Data entry prior to pharmacist verification is part of the dispensing workflow, but it is the pharmacist's clinical review that constitutes the practice of pharmacy. The technician's entry alone does not rise to the level of professional pharmacy practice. So remember, drug therapy evaluation is the practice of pharmacy. Data entry and medication administration are not. Question 12. A compounding pharmacy prepares progesterone suppositories weekly without individual patient prescriptions, anticipating future demand, and ships them to multiple clinics across state lines. Under the FDCA, this is most consistent with which classification? Option A, a 503A traditional compounding pharmacy operating within permissible anticipatory compounding limits. Option B, a 503B outsourcing facility, which may compound without patient-specific prescriptions and distribute across state lines under CGMP. Option C, a wholesale drug distributor under the DSCSA, since it ships finished drug products to facilities. The correct answer is B, a 503B outsourcing facility, which may compound without patient-specific prescriptions and distribute across state lines under CGMP. Here's why. Federal law, enacted by the Drug Quality and Security Act of 2013, was created specifically for entities that compound in bulk without patient-specific prescriptions and distribute to healthcare facilities across state lines. 503B facilities must register with FDA, comply with CGMP, and submit to FDA inspection. Option A is wrong because Option A incorrectly characterizes this as permissible 503A activity. Under 503A, traditional compounders must compound based on individual patient prescriptions. Routine batch compounding without patient-specific prescriptions and interstate distribution at scale exceeds 503A scope. Option C is wrong because Option C misapplies the DSCSA wholesale distributor category. An entity that is itself compounding drugs, producing them rather than distributing pre-manufactured products, cannot satisfy DSCSA requirements through a wholesale distributor registration alone. So remember, no patient-specific prescription plus ships across state lines equals 503B outsourcing facility. Question 13. A drug manufacturer's sales representative offers a pharmacist a $500 gift card for the pharmacy's high-volume dispensing of their brand name product. Under federal law, which statement is most accurate? Option A. The gift constitutes a potential violation of the federal anti-kickback statute if intended to induce referrals or purchases of federally reimbursable drugs. Option B. The gift is permissible under the anti-kickback statute's promotional items safe harbor, which allows pharmaceutical manufacturers to provide items of nominal educational value. A $500 gift card exceeds the safe harbor threshold, but requires enhanced disclosure rather than rejection. Option C. The gift violates the anti-kickback statute only if the pharmacy subsequently makes a formulary change or documented purchasing commitment linked to the gift. Absent a recorded formulary decision following receipt, the requisite intent to induce federally reimbursable purchases is not established. The correct answer is A. The gift constitutes a potential violation of the federal anti-kickback statute if intended to induce referrals or purchases of federally reimbursable drugs. Here's why. The federal anti-kickback statute prohibits offering, paying, soliciting, or receiving anything of value to induce or reward referrals or purchases of items covered by federal healthcare programs. There is no de minimis threshold and no professional category exemption. Option B is wrong because Option B invents a safe harbor disclosure option for a $500 gift card. The anti-kickback statute's safe harbors do not permit cash equivalent gifts of this magnitude as merely disclosable promotional items. No AKS safe harbor converts a $500 cash equivalent offered to induce federally reimbursable drug purchases into a disclosable but permissible transaction. Option C is wrong because Option C incorrectly requires a documented formulary change as a prerequisite for a violation. The anti-kickback statute's prohibition is triggered by offering or receiving anything of value to induce purchases of federally reimbursable items. The inducement intent creates liability even without a subsequent formulary addition or purchasing record. So remember, the anti-kickback statute has no dollar amount de minimis exception. Any remuneration intended to induce is prohibited. Question 14. Under the NABP Model Act and uniform state law principles, which oversight structure is required at a remote telepharmacy dispensing site? Option A. A pharmacist at a central hub supervises the remote site via real-time two-way audiovisual technology, while a technician performs dispensing functions at the remote site. Option B. A pharmacist at the central hub reviews prescriptions via secure asynchronous messaging. The remote technician may dispense pending pharmacist review, as long as all controlled substance transactions are reconciled within 24 hours and a pharmacist countersign is obtained. Option C. A licensed pharmacy intern at the remote site may perform dispensing functions under telephone supervision from the central pharmacist. Real-time audiovisual technology is required only for controlled substance dispensing events in rural telepharmacy settings under current Model Act provisions. The correct answer is A. A pharmacist at a central hub supervises the remote site via real-time two-way audiovisual technology, while a technician performs dispensing functions at the remote site. Here's why. The NABP Model Act's telepharmacy framework permits a hub pharmacist to supervise a remote dispensing site through real-time two-way audiovisual communication. A qualified technician at the remote site performs dispensing functions under this remote supervision. Option B is wrong because Option B substitutes secure asynchronous messaging and retrospective reconciliation for the real-time audiovisual supervision the Model Act requires. Telepharmacy requires synchronous, real-time two-way audiovisual communication during the dispensing event, not after the fact review of transactions already completed. Option C is wrong because Option C substitutes an intern for a qualified technician and reduces real-time supervision to telephone-only contact. The Model Act's telepharmacy framework requires continuous real-time two-way audiovisual supervision and does not create a rural exception, reducing the technology standard to telephone-only oversight for any category of prescription. So remember, telepharmacy works because a hub pharmacist supervises via real-time audiovisual. The technician dispenses under that supervision. Question 15. A pharmacist discovers a colleague is diverting controlled substances for personal use. What is the most appropriate first obligation? Option A. Report the suspected diversion to the DEA, the pharmacy's management or PIC, and the State Board of Pharmacy as appropriate. Option B. Confront the colleague privately to allow voluntary self-reporting to the DEA and PIC within 30 days. If the colleague fails to self-report within that window, notify the PIC and allow the Board of Pharmacy to identify the issue through its own periodic audit processes. Option C. delete or modify the dispensing records showing patterns consistent with diversion to protect the colleague from board action, because pharmacy record-keeping systems allow pharmacists correction of entries and the DEA does not conduct retrospective audits of records older than 2 years. The correct answer is A. Report the suspected diversion to the DEA, the pharmacy's management or PIC, and the State Board of Pharmacy as appropriate. Here's why. Drug diversion is a serious federal crime under the CSA and a threat to patient safety. When a pharmacist discovers or suspects diversion, the obligation is immediate. Notify management and the PIC, report to the DEA. Significant loss requires DEA Form 106 under federal regulations and notify the state board. Option B is wrong because Option B creates a 30-day private confrontation period before reporting. Allowing continued access to controlled substances during a grace period permits ongoing diversion and patient harm. DEA significant loss reporting under federal regulations must occur as soon as the pharmacist becomes aware, not after a self-reporting window expires. Option C is wrong because Option C describes deliberate record destruction or falsification. Controlled substance records must be maintained for at least 2 years under federal regulations. Altering or destroying records to conceal diversion constitutes federal records falsification and obstruction of a federal investigation under federal law, independent of the underlying diversion. So remember, diversion is a federal crime. Report to management, DEA, and the board. Covering it up creates criminal liability for you. Question 16. Which statement most accurately describes pharmacist health and recovery programs under the NABP Model Act and uniform state law principles? Option A. Any pharmacist who has previously received board discipline for a controlled substance violation, including those who completed treatment and returned to practice under monitoring conditions, must permanently surrender their DEA registration upon voluntary disclosure to a peer assistance program. Option B. Pharmacists who voluntarily self-report substance use disorders and participate in an approved recovery program may continue practicing under monitoring conditions rather than facing immediate revocation. Option C. Pharmacist peer assistance programs for substance use disorders are federally operated by the DEA's Diversion Control Program, which certifies approved treatment programs and actively monitors participants' prescription dispensing activity throughout the recovery period. The correct answer is B. Pharmacists who voluntarily self-report substance use disorders and participate in an approved recovery program may continue practicing under monitoring conditions rather than facing immediate revocation. Here's why. Most state boards and the NABP Model Act encourage pharmacists with substance use disorders to voluntarily enter peer assistance programs. The policy rationale is rehabilitative. Voluntary reporting with monitoring allows treatment, while the board ensures public safety through ongoing oversight. Option A is wrong because Option A incorrectly requires permanent DEA registration, surrender upon peer assistance enrollment. Peer assistance programs are designed to rehabilitate. Voluntary enrollment allows continued practice under monitoring conditions, which is the program's core policy rationale. The Model Act does not impose permanent exclusion for pharmacists who voluntarily seek help. Option C is wrong because Option C incorrectly attributes pharmacist peer assistance to the DEA. These programs are state administered, typically through state pharmacy associations or boards of pharmacy. The DEA's Diversion Control Program focuses on registration compliance and illegal distribution, not pharmacist rehabilitation. No federal agency operates pharmacist peer assistance programs. So remember, voluntary self-reporting opens a rehabilitation pathway with monitored practice. It does not automatically mean license revocation. Question 17. A pharmacist wants to administer influenza vaccines under a statewide standing order without a patient-specific physician order, under the NABP Model Act and uniform state law principles. Which statement most accurately describes the authority? Option A. The FDCA explicitly authorizes pharmacist vaccine administration nationwide, superseding any state licensure requirement. Option B. Pharmacists may never administer vaccines without a patient-specific written prescription because immunization is outside pharmacy practice. Option C. A pharmacist may administer vaccines under a valid CPA or statewide standing order, provided they meet applicable training and documentation requirements. The correct answer is C. A pharmacist may administer vaccines under a valid CPA or statewide standing order, provided they meet applicable training and documentation requirements. Here's why. Under the NABP Model Act and uniform state law principles, pharmacist-administered immunizations are authorized through state law mechanisms, CPAs, statewide standing orders, or protocols issued by state health authorities. Patient-specific prescriptions are not required when a valid standing order or protocol exists. Option A is wrong because Option B overstates federal authority. The FDCA does not categorically authorize pharmacist vaccine administration nationwide without any state role. Federal provisions like the PrEP Act create temporary authorizations during emergencies, but do not permanently supersede state pharmacy practice acts. Option B is wrong because Option B describes a legal landscape that no longer exists. Pharmacist-administered immunizations are within the recognized scope of pharmacy practice in all U.S. jurisdictions under state law. So remember, pharmacist vaccine authority comes from state CPAs or standing orders. The PrEP Act is an emergency expansion, not the baseline. Question 18. Under OBRA 90, which set of elements most completely describes what must be offered during pharmacist counseling for a new outpatient prescription? Option A. Drug name and description, dosage form and route, duration of therapy, special directions and precautions, common side effects and interactions, self-monitoring techniques, storage, refill information, and action if a dose is missed. Option B, under OBRA 90, the pharmacist's counseling offer must address the information printed on the prescription label. Additional counseling elements beyond label content are recommended best practice, but are not statutorily required for the offer to be compliant. Option C, OBRA 90 requires the pharmacist to offer discussion of drug name, dosage form, major adverse effects, and storage instructions. The remaining elements in the statutory list are aspirational standards recommended by CMS guidance but not mandated for every individual counseling offer. The correct answer is A. Drug name and description, dosage form and route, duration of therapy, special directions and precautions, common side effects and interactions, self-monitoring techniques, storage, refill information, and action if a dose is missed. Here's why. Federal law specifies a comprehensive list of counseling elements for new Medicaid prescriptions. The offer must be made proactively. If declined, the refusal should be documented in accordance with OBRA 90's implementation through state Medicaid plans and board rules. The law does not wait for the patient to initiate. Option B is wrong because option B limits required counseling to label content. OBRA 90 requires discussion of elements enumerated in which go well beyond what any prescription label contains, including self-monitoring techniques, what to do if a dose is missed, drug interactions, and storage. Reading the label does not satisfy the statutory counseling requirements. Option C is wrong because option C correctly identifies some required elements, but incorrectly treats the remaining statutory elements as optional guidance. The elements enumerated in are a mandatory minimum, not a menu from which the pharmacist selects. All enumerated elements must be included in the offer. So remember, OBRA 90 counseling is a comprehensive verbal offer. Written materials supplement it but never replace it. Question 19. A pharmacy co-located with a physician's office is asked to share patient prescription records for marketing a new weight loss service. Under HIPAA, which statement is correct? Option A. This is permissible because both entities are co-located and constitute a single covered entity. Option B. Written patient authorization is required because marketing is not a HIPAA permitted use of PHI without consent. Option C. This is permissible because the physician is a treating provider and no authorization is needed for treatment disclosures. The correct answer is B. Written patient authorization is required because marketing is not a HIPAA permitted use of PHI without consent. Here's why. Under federal regulations, using or disclosing PHI for marketing purposes requires prior written patient authorization. Marketing is explicitly excluded from the treatment, payment, and healthcare operations exception. Co-location does not create a single covered entity relationship. Option A is wrong because option A misapplies the healthcare operations exception. The operations exception covers activities like quality review, not external marketing of new services. Marketing requires authorization regardless of physical proximity. Option C is wrong because option C correctly states treatment disclosures to treating providers do not need authorization, but misidentifies this situation. Sharing records to market a weight loss program is a marketing use, not a treatment activity. So remember, co-location does not create a single HIPAA entity. Marketing always requires written patient authorization. Question 20. A pharmacist receives a faxed oxycodone 30 milligrams /120 prescription missing the patient's address. Under federal law for Schedule II substances, what is the most appropriate action? Option A. Dispense the prescription after adding the missing address from the patient's pharmacy profile, because existing records in the pharmacy system constitute valid documentation of the required element and satisfy without contacting the prescriber. Option B. Contact the prescriber's office for the missing address before dispensing and annotate the prescription accordingly. Option C. Refuse to dispense and destroy the faxed prescription to prevent unauthorized use because an incomplete Schedule II prescription cannot be corrected under any circumstance and must be voided immediately with a new prescription required from the prescriber. The correct answer is B. Contact the prescriber's office for the missing address before dispensing and annotate the prescription accordingly. Here's why. Under federal regulations, a valid Schedule II prescription must include the patient's full name and address. A prescription missing a required element is incomplete. The appropriate response is to contact the prescriber's office, obtain the missing information, annotate the prescription, then dispense. Option A is wrong because Option A incorrectly authorizes self-completing the missing element from pharmacy records without prescriber contact. Under federal regulations, required prescription elements must be issued by the prescriber. The pharmacist may not supply missing required information from their own records. The prescriber's office must authorize and document any correction. Option C is wrong because option C is unnecessarily destructive. The deficiency, a missing patient address, is correctable by contacting the prescriber's office and documenting the correction. Destroying the prescription deprives the patient of a legitimate medication and is not required by the appropriate response is to obtain and annotate the missing information. So remember, patient address is a required element on Schedule 2 prescriptions. Get it from the prescriber before dispensing. Question 21. Under OBRA 90, which activity most accurately describes the pharmacist's prospective DUR obligation? Option A, reviewing the patient's complete prescription history across all dispensers, annually using PDMP data to identify duplicated therapies, excessive quantities, or multiple prescriber patterns that suggest diversion or clinical misuse of federally reimbursed drugs. Option B, screening each new prescription before dispensing for drug-drug interactions, therapeutic duplication, incorrect dosing, and contraindications, then acting on any identified issues. Option C, submitting a report to CMS or the state Medicaid agency after each new Medicaid prescription, documenting the DUR screening findings, clinical interventions made, and prescriber consultations initiated during the pre-dispensing review process. The correct answer is B, screening each new prescription before dispensing for drug-drug interactions, therapeutic duplication, incorrect dosing, and contraindications, then acting on any identified issues. Here's why. OBRA 90 requires pharmacists to perform prospective DUR, a review before dispensing each prescription. The screening must cover drug-drug interactions, therapeutic duplication, incorrect dose or duration, drug allergy interactions, drug disease contraindications, and clinical abuse or misuse. Option A is wrong because option A describes retrospective DUR, which OBRA 90 also requires, but as a separate population level obligation. Retrospective DUR is an after dispensing aggregate pattern analysis. Prospective DUR is an individual patient pre-dispense clinical screening that occurs before each prescription is released. The two obligations are distinct. Option C is wrong because option C describes an administrative reporting function to CMS, while OBRA 90 requires state Medicaid agencies to maintain DUR programs with reporting obligations. The individual pharmacist's prospective DUR duty is a patient-specific clinical screening at the point of dispensing, not a real-time filing to a government agency for each prescription dispensed. So remember, prospective DUR under OBRA 90 happens before every dispense, screen for interactions, duplications, and contraindications. Question 22. A pharmacist wants to enter into a CPA with a physician for anticoagulation management. Under the NABP Model Act and uniform state law principles, which element is generally required for a valid CPA? Option A, prior FDA approval before initiating the CPA because pharmacist participation in disease management programs that modify drug therapy constitutes practice of medicine requiring federal regulatory clearance under FDCA authority governing health practice arrangements. Option B, Schedule 2 and 3 prescribing authority granted to the pharmacist through the CPA, allowing the pharmacist to initiate and modify controlled substance therapy without separate prescriber review for each individual clinical decision under the agreement. Option C, a written agreement specifying the scope of the pharmacist's authority, the conditions under which the pharmacist may act, and the collaborating practitioner's information. The correct answer is C, a written agreement specifying the scope of the pharmacist's authority, the conditions under which the pharmacist may act, and the collaborating practitioner's information. Here's why. The NABP Model Act requires CPAs to be documented in writing and must specify the pharmacist's delegated scope, the clinical conditions covered, any protocols to follow, and the collaborating practitioners identifying information. Option A is wrong because Option A invents an FDA pre-approval requirement for CPAs. Collaborative pharmacy practice is authorized by state law under the Model Act. The FDA regulates drug approvals and manufacturer conduct. It has no authority over and does not approve individual state-authorized pharmacist-physician practice arrangements. Option B is wrong because Option B incorrectly extends CPA authority to controlled substance prescribing. A CPA governs drug therapy management within established protocols. It does not confer independent controlled substance prescribing authority. Initiating or modifying Schedule 2-3 therapy requires a DEA-registered prescriber's independent decision for each clinical change. So remember, a CPA must be in writing, naming the pharmacist's scope of authority, the covered conditions, and the collaborating prescriber. Question 23. A pharmacist joins a non-sterile compounding pharmacy and discovers no competency assessments have been conducted for compounding staff. Under USP Chapter 795, which statement is most accurate? Option A. Competency assessments under USP 795 are optional if a supervising pharmacist is present during all compounding. Option B. Competency assessments are only required for sterile compounding under USP 797. Non-sterile compounding under USP 795 has no personnel assessment requirements. Option C. All personnel performing non-sterile compounding must demonstrate competency through initial and ongoing assessments, including at least annual evaluation. The correct answer is C. All personnel performing non-sterile compounding must demonstrate competency through initial and ongoing assessments, including at least annual evaluation. Here's why. USP Chapter 795 requires all personnel involved in non-sterile compounding, pharmacists and technicians alike, to demonstrate competency through documented initial training and ongoing evaluations at least annually. This requirement is not optional and is not waived by supervisory presence. Option A is wrong because Option B incorrectly suggests supervisory presence waives the documentation requirement. Supervisory oversight and formal competency assessment serve different functions. One does not substitute for the other. Option B is wrong because Option B incorrectly limits competency requirements to sterile compounding. USP 795 imposes its own personnel competency standards for non-sterile compounding, separate from USP 797's requirements. So remember, USP 795 requires documented competency assessments for everyone, both pharmacists and technicians, at least annually. Question 24. Under the NABP Model Act and uniform state law principles, which scenario most clearly requires the pharmacist to refuse to dispense? Option A, a Schedule 2 prescription where the quantity appears altered from 30 to 300 in a noticeably different ink. Option B, a Schedule II oxycodone prescription from a licensed out-of-state DEA registered physician for an established chronic pain patient. Option C, a patient who always pays cash and occasionally requests early refills on controlled substances. The correct answer is A, a Schedule II prescription where the quantity appears altered from 30 to 300 in a noticeably different ink. Here's why. A prescription showing visible physical alteration, particularly a quantity change in different ink on a Schedule II substance, is strong evidence of forgery. Under the corresponding responsibility doctrine, the pharmacist must refuse to dispense and should retain the prescription and contact the prescriber to confirm authenticity. Option B is wrong because Option B describes a facially valid prescription, licensed practitioner, valid DEA registration, established patient. Out-of-state prescriptions from DEA registered practitioners are federally valid. No basis for refusal exists. Option C is wrong because Option C describes risk factors warranting heightened scrutiny. Cash payment and early refill requests are red flags requiring investigation, but they do not alone establish that the prescription is illegitimate. So remember, visible alterations on a prescription require refusal. Corresponding responsibility demands it. Question 25. By accepting the PIC designation at a pharmacy with existing compliance violations, which responsibilities does the pharmacist assume under the NABP Model Act and uniform state law principles? Option A, personal financial liability only for compliance violations that occurred after the PIC designation date. The incoming PIC is professionally insulated from board disciplinary action for deficiencies created before their arrival as long as they were not personally involved. Option B, responsibility for ongoing legal compliance, corrective action for existing deficiencies, and professional accountability to the Board of Pharmacy going forward. Option C, administrative scheduling and staffing duties only. The pharmacy owner or corporate entity retains all DEA registration compliance and board accountability because the DEA registration belongs to the business entity, not to the individual pharmacist designated as PIC. The correct answer is B. Responsibility for ongoing legal compliance, corrective action for existing deficiencies, and professional accountability to the Board of Pharmacy going forward. Here's why. Accepting the PIC designation is a formal legal and professional act. The PIC assumes prospective responsibility for the pharmacy's compliance, including addressing existing deficiencies upon appointment. This responsibility cannot be delegated back to the owner. Option A is wrong because Option A partially captures the prospective nature of PIC liability but understates the obligation. Upon accepting the designation, the PIC is professionally accountable to the board for addressing existing compliance deficiencies going forward. Ignoring known violations after accepting the PIC role is itself a board actionable failure. Option C is wrong because Option C incorrectly bifurcates PIC functions from compliance responsibility. The PIC designation explicitly assigns personal professional accountability for the pharmacy's legal compliance under the Model Act. The fact that a DEA registration belongs to the entity does not transfer the PIC's personal compliance obligations back to the business owner. So remember, accepting the PIC role means owning prospective compliance and fixing existing deficiencies. You can't delegate that to the owner. Question 26. A drug has lost measurable potency after its labeled expiration date. Under the FDCA, this product is most accurately classified as Option A, misbranded, because the label's expiration date is now false or misleading. Option B, counterfeit, because the manufacturer's claims about the product can no longer be verified. Option C, adulterated, because its strength falls below the standard it purports or is represented to possess. The correct answer is C, adulterated, because its strength falls below the standard it purports or is represented to possess. Here's why. Federal law defines a drug as adulterated if its strength differs from, or its purity or quality falls below, the standard set forth in an official compendium or that which it purports or is represented to possess. A drug that has expired and lost measurable potency fails this strength standard. This is the statutory definition of adulteration. Option A is wrong because Option A applies misbranding under federal law, which governs false or misleading labeling. Because the product's strength falls below what it purports to possess, it clearly meets the FDCA definition of an adulterated drug under federal law. A product can be both adulterated and misbranded in other contexts, but for exam purposes, adulteration is the key classification to recognize when strength or quality falls below labeled standards. Option B is wrong because Option B applies the counterfeiting definition at, which concerns products that imitate or misrepresent the identity or origin of a genuine product. An expired drug from the legitimate manufacturer that has lost potency has not been counterfeited. It was authentically manufactured but degraded. Degradation of a genuine product is adulteration. So remember, an expired drug with measurable potency loss meets the FDCA definition of adulterated. Question 27. During a declared state emergency, a patient with documented hypertension has exhausted their lisinopril supply and cannot reach their prescriber. Which action is most clearly authorized under the NABP Model Act's emergency dispensing provisions? Option A, dispense a 30-day emergency supply of the Schedule II opioid the patient reports taking, documenting clinical necessity under the DEA's emergency oral prescription provision, because a declared state emergency activates Federal Emergency Schedule II, dispensing without a prescriber call. Option B, dispense a limited non-controlled medication supply sufficient to bridge until the prescriber can be reached, document the emergency dispensing, and notify the prescriber as soon as practical. Option C, decline to dispense because the Model Act's emergency dispensing provision is only activated when the governor has issued a specific pharmacy emergency access order. A general state emergency declaration alone does not confer pharmacist emergency dispensing authority. The correct answer is B. Dispense a limited non-controlled medication supply sufficient to bridge until the prescriber can be reached. Document the emergency dispensing and notify the prescriber as soon as practical. Here's why. The Model Act authorizes emergency dispensing of non-controlled maintenance medications when the prescriber is unavailable and withholding the drug would endanger the patient. Lisinopril for documented hypertension is a paradigm case. Abrupt discontinuation carries cardiovascular risk. Documentation and prescriber notification are required. Option A is wrong because Option A incorrectly invokes the DEA's emergency oral prescription provision and misapplies it to a state emergency context. DEA Emergency Schedule II oral prescriptions require an authorized prescriber to phone the prescription directly to the pharmacist. A state emergency declaration does not eliminate this requirement. Additionally, the Model Act's emergency dispensing provision applies to non-controlled medications only. Option C is wrong because option C incorrectly requires a specific pharmacy access executive order before emergency dispensing authority applies. Model Act. Section 6's emergency dispensing provision is activated by clinical circumstances, prescriber unavailability combined with patient jeopardy from withholding a maintenance medication, not by the formal category of emergency declaration. So remember, emergency dispensing covers non-controlled bridge supplies only. Schedule 2 and Schedule 1 rules are never suspended. Question 28. Which of the following activities falls within the lawful scope of a pharmacy technician under the NABP Model Act when performed under pharmacist supervision? Option A, entering prescription data into the dispensing software and preparing labels for pharmacist review. Option B, providing individualized patient counseling about a new medication's mechanism of action and side effects. Option C, performing the final verification of a filled prescription and releasing it to the patient. The correct answer is A, entering prescription data into the dispensing software and preparing labels for pharmacist review. Here's why. Pharmacy technicians may perform dispensing support functions under pharmacist supervision, including data entry, label generation, and medication preparation. Final verification and patient counseling are reserved for licensed pharmacists under the Model Act because they require professional judgment that only pharmacist licensure confers. Option B is wrong because option B describes patient counseling, which the Model Act expressly reserves for licensed pharmacists. Counseling requires professional judgment to assess patient understanding, identify unreported interactions, and address clinical concerns. Activities requiring pharmacist licensure. A technician may facilitate the encounter, but the counseling itself is pharmacist exclusive. Option C is wrong because option C describes final prescription verification, the pharmacist's professional review step. Under the base Model Act, this is reserved for pharmacists. Tech Check Tech programs exist in some states but require express statutory authorization beyond the baseline Model Act. So remember, technicians handle data entry and prep support. Final verification, counseling, and clinical decisions belong to the pharmacist. Question 29. A chain pharmacy requires pharmacists to process 15 prescriptions per hour. A pharmacist believes this quota compromises their ability to perform adequate DUR and counseling. Which statement best describes the pharmacist's professional responsibility? Option A. The pharmacist must comply with the 15 prescription per hour production standard because corporate operational policies establish the applicable standard of care. Under Respondent Superior, liability for any resulting dispensing errors shifts to the employer rather than the individual pharmacist. Option B. The pharmacist should document their concerns and, if the workload genuinely compromises patient safety, is professionally obligated to address this regardless of corporate policy. Option C. The pharmacist may reassign prospective DUR screening to a certified pharmacy technician to meet the production target, provided the pharmacist reviews the technician's flagged findings before releasing each prescription. This supervised delegation satisfies OBRA 90's prospective DUR requirement. The correct answer is B. The pharmacist should document their concerns, and if the workload genuinely compromises patient safety, is professionally obligated to address this regardless of corporate policy. Here's why. The pharmacist's primary duty is to patient safety and the public health, not to corporate production quotas. OBRA 90 and the NABP Model Act make clear that compliance with an employer quota does not shield a pharmacist from professional discipline for patient harm resulting from inadequate clinical review. In a growing number of states, boards and legislatures have taken action against prescription quotas that interfere with professional judgment, though UMPJE focuses on the underlying duty. The pharmacist's clinical obligations are not overridden by corporate metrics. Option A is wrong because Option A incorrectly elevates employer policy to define the standard of care and shifts all liability to the employer. Respondent superior may expose the employer, but pharmacists retain independent professional obligations under OBRA 90 and the Model Act. Following a quota that compromises clinical DUR does not shield the pharmacist from personal professional discipline or patient liability. Option C is wrong because Option C proposes delegating DUR to a technician under pharmacist review. Under the Model Act, Prospective DUR is a non-delegable pharmacist function requiring professional clinical judgment. A technician may gather patient information and enter data, but the clinical screening for interactions, contraindications, and therapeutic duplication must be performed by the pharmacist. Delegation with after-the-fact review is insufficient. So remember, patient safety outranks corporate production quotas, and DUR can never be delegated to a technician. Question 30. A pharmacist in a federally qualified health center provides MTM services under the Medicare Modernization Act of 2003, which patients are eligible for Medicare Part D covered MTM. Option A. Part D enrollees with 2 or more chronic conditions taking multiple Part D covered drugs. Plans typically set thresholds at 2+ conditions and often 5 or more medications, and likely to incur high annual drug costs. Option B, only Medicare Part A inpatient beneficiaries whose hospital discharge included 5 or more medications qualify for Part D MTM follow-up. The Part D MTM benefit is available exclusively as a transition of care service within 90 days of hospital discharge under CMS rules. Option C, all Medicare Part D enrollees automatically qualify for MTM services upon enrollment. Part D plans must offer MTM to every beneficiary as a mandatory plan component, regardless of medication burden, number of chronic conditions, or projected drug costs. The correct answer is A. Part D enrollees with 2 or more chronic conditions taking multiple Part D covered drugs. Plans typically set thresholds at 2+ conditions and often 5 or more medications, and likely to incur high annual drug costs. Here's why. Under that provision, Medicare Part D plans must offer MTM programs to enrollees meeting 3 eligibility criteria. 1, 2 or more chronic conditions. 2, multiple Part D covered drugs. Plans set their own specific thresholds, but 5 or more medications is the most commonly cited benchmark in current exam preparation materials. And 3, likelihood of incurring annual drug costs exceeding a CMS set threshold. Not all Part D enrollees qualify. Option B is wrong because Option B describes Part A, inpatient services, and a transition of care model rather than the Part D MTM framework. Medicare Part D MTM is an outpatient benefit for ambulatory beneficiaries managing chronic conditions. It is not limited to post-hospitalization transitions or Part A enrollees. The MMA created a standalone targeted outpatient program. Option C is wrong because Option C describes universal Part D enrollment as the eligibility standard. The MMA's MTM program is intentionally targeted at high-risk, high-cost beneficiaries, requiring MTM for all enrollees, regardless of medication burden, would be cost-prohibitive and would dilute the program's focus on complex patients who benefit most. So remember, Part D MTM eligibility requires the triple trigger: multiple chronic conditions, multiple Part D drugs, and high drug costs. Question 31. A prescriber calls in a verbal order for hydromorphone, 4 mg tablets, quantity 60 with 2 refills. Under the CSA and DEA regulations, which statement is most accurate? Option A, hydromorphone is Schedule 2. Verbal prescriptions are not permitted except in genuine emergencies, and Schedule 2 drugs may not be refilled. Option B, the order is acceptable because the pharmacy may accept it and follow up with written confirmation. Option C, the order is valid because hydromorphone is treated as Schedule 3 for telephonic prescribing purposes. The correct answer is A. Hydromorphone is Schedule 2. Verbal prescriptions are not permitted except in genuine emergencies, and Schedule 2 drugs may not be refilled. Here's why. Hydromorphone is Schedule 2 under federal regulations. Under federal regulations, Schedule 2 prescriptions must be issued in writing with a wet ink signature or via DEA-compliant EPCS. Verbal prescriptions are only permitted for genuine emergencies with written follow-up within 7 days. Additionally, Schedule 2 prescriptions cannot be refilled. The 2 refills is itself an independent violation. Option B is wrong because Option B describes an oral plus written confirmation process that applies to Schedule 3V under federal regulations, not Schedule 2. No confirmation mechanism exists for routine Schedule 2 verbal prescriptions outside of a genuine emergency. Option C is wrong because Option C misstates hydromorphone's scheduling. Hydromorphone is and has always been Schedule 2 under federal regulations. There is no category of opioid analgesic treated as Schedule 3 for telephonic prescribing. So remember, Schedule 2 never allows verbal orders except genuine emergencies, and Schedule 2 prescriptions can never be refilled. Question 32. A pharmacy lacks the full quantity of a Schedule 2 oxycodone prescription. Under DEA regulations, which of the following most accurately describes the partial fill rules for Schedule 2 controlled substances? Option A. The remainder is valid for 6 months from the date of issue, applying the same validity window that governs Schedule 3 through V prescriptions. Schedule 2 partial fill validity follows the same 6-month federal timeline as refill validity for lower schedules. Option B. Schedule 2 prescriptions are never eligible for partial fills under any patient circumstances. If the pharmacy cannot supply the full quantity, the prescription is void and the patient must return to the prescriber for a new complete prescription before any controlled substance is dispensed. Option C. For a general outpatient with an insufficient stock situation, the remainder must be dispensed within 72 hours or it is void. Additionally, under the Support Act, any patient or prescriber may request a partial fill with the balance valid for 30 days from the date written. The correct answer is C. For a general outpatient with an insufficient stock situation, the remainder must be dispensed within 72 hours or it is void. Additionally, under the Support Act, any patient or prescriber may request a partial fill with the balance valid for 30 days from the date written. Here's why. 3 distinct partial fill scenarios exist for Schedule II prescriptions under federal law. 1. Pharmacy stock shortage. Under federal regulations, if the pharmacy cannot supply the full quantity, the remainder must be dispensed within 72 hours, or it is void and a new prescription is required. 2. LTCF patients and terminally ill patients. Under federal regulations, the remaining balance is valid for up to 60 days from the date written. 3. Patient or prescriber requested partial fill. Under the Support Act 2018, any Schedule II prescription may be partially filled at the patient's or prescriber's request, with the balance valid for 30 days from the date written. Option B correctly captures both the 72-hour stock shortage rule and the Support Act 30-day patient request rule. Option A is wrong because Option A applies the schedule. 3V 6-month validity window to Schedule II partial fills. Schedule II prescriptions cannot be refilled under any circumstances, and partial fill validity is governed by a separate provision. The 6-month window under federal regulations governs Schedule III VI refills only. It has no application to Schedule II partial fills. Option B is wrong because Option B incorrectly prohibits all Schedule II partial fills. 3 federal scenarios expressly authorize Schedule II partial fills. 1. 72-hour stock shortage. 2. 60-day validity for LTCF or terminally ill patients. And 3. 30-day patient or prescriber requested partial fill under the Support Act. A blanket prohibition does not reflect current federal law. So remember, a Schedule II partial fill remainder must be dispensed within 72 hours. After that, it's void and a new prescription is required. Question 33. A patient presents an alprazolam 1 mg #30 prescription with 5 refills from a physician licensed in another state. Under federal DEA regulations, which statement is most accurate? Option A. Alprazolam is Schedule IV. The prescription is federally valid if the prescriber holds a valid DEA registration and the prescription meets all required elements. 5 refills is within the Schedule IV limit. Option B. The prescription is federally invalid because the prescribing physician's DEA registration is issued in a different state. DEA regulations require the prescriber's DEA registration to be registered in the same state where the prescription is written for the prescription to be federally valid. Option C. Alprazolam is limited to 2 refills under Schedule IV federal law, making 5 refills a federal violation. The pharmacist must adjust the refill count to 2 before dispensing or contact the prescriber for a corrected prescription listing the federally compliant refill number. The correct answer is A. Alprazolam is Schedule IV. The prescription is federally valid if the prescriber holds a valid DEA registration and the prescription meets all required elements. 5 refills is within the Schedule IV limit. Here's why. Alprazolam is Schedule IV. Under federal regulations, Schedule IV prescriptions may be refilled up to 5 times within 6 months from the date of issue. So 5 refills is at the maximum but not in excess. A prescription from an out-of-state DEA registered practitioner is federally valid. Federal law does not require the prescriber and pharmacy to be in the same state. Option B is wrong because Option B incorrectly restricts out-of-state prescriptions by DEA registration state. DEA registrations are national credentials. A practitioner's DEA number is valid across all states. Federal law does not require the DEA registration state to match the prescribing state. State scope of practice laws may impose separate restrictions, but the federal prescription validity standard does not. Option C is wrong because Option C states an incorrect refill limit. Under federal regulations, Schedule 3 and IV prescriptions may be refilled up to 5 times within 6 months. 5 refills is the maximum, but is not a violation. A 2 refill cap applies to no current federal controlled substance schedule and is a common misconception, possibly confused with state-specific rules. So remember, Schedule IV allows up to 5 refills within 6 months. Out-of-state prescriptions are valid if the prescriber has a DEA registration. Question 34. A patient asks to transfer their Schedule 3 buprenorphine naloxone prescription from one pharmacy to another. Both pharmacies use separate dispensing systems. Under federal law, how many times may this prescription be transferred? Option A, once per prescription lifetime when pharmacies use separate systems. Option B, an unlimited number of times because buprenorphine is on the opioid treatment list. Option C, never. Buprenorphine naloxone may not be transferred between pharmacies under any circumstances. The correct answer is A, once per prescription lifetime when pharmacies use separate systems. Here's why. Under federal regulations, a Schedule 3, IFUR, or V prescription may be transferred between pharmacies, but only once per prescription lifetime when pharmacies use separate systems. The exception allowing multiple transfers applies only when pharmacies electronically share a real-time database because shared systems prevent duplication. Option B is wrong because Option B describes the multiple transfer rule that applies only when pharmacies share a real-time electronic database under federal regulations. With separate systems, the single transfer limit applies. Buprenorphine's opioid treatment characteristics do not create a special transfer exception. Option C is wrong because Option C incorrectly states buprenorphine naloxone can never be transferred. Suboxone is Schedule 3 and follows standard Schedule 3V transfer rules under federal regulations. No categorical prohibition on transfers exists for this substance. So remember, Schedule 3 through V prescriptions can only be transferred once, unless both pharmacies share a real-time database. Question 35. Must the Federal Controlled Substance Schedule designation such as C2 appear on the pharmacist-prepared dispensing label given to the patient for a Schedule 2 prescription? Option A, no. The schedule designation requirement under federal regulations applies to manufacturer labeling and commercial containers, not to the pharmacist-prepared dispensing label. Option B, yes, the schedule designation must appear on all dispensed labels for Schedule 2 and tertiary substances. Schedule 9V and V prescriptions are exempt from the dispensing label schedule symbol requirement because those schedules carry lower diversion risk under federal regulations. Option C, yes, the schedule designation is required on all dispensed controlled substance labels under federal regulations, which governs the required elements of Schedule 2 through V dispensing labels and mandates inclusion of the schedule symbol to alert patients and caregivers. The correct answer is A and no. The schedule designation requirement under federal regulations applies to manufacturer labeling and commercial containers, not to the pharmacist-prepared dispensing label. Here's why. Under federal regulations, the requirement to display the controlled substance schedule symbol applies to manufacturer labeling and commercial containers, not to the individual dispensing label prepared by the pharmacist for the patient. A federal caution statement is required on dispensed Schedule II labels under federal regulations, but the schedule symbol itself is a manufacturer container requirement. Option B is wrong because Option B creates a partial schedule designation requirement for some schedules on dispensed labels. No federal provision requires the schedule symbol on any dispensed prescription label for any schedule. The schedule symbol requirement under federal regulations applies exclusively to manufacturer, labeling, and commercial containers, not to individual dispensed prescription labels. Option C is wrong because Option C cites, which does govern dispensing label requirements. However, the elements listed in 1306.14, pharmacy name and address, dispensing date, prescription number, patient name, prescriber name, and directions, do not include the schedule symbol. The schedule symbol requirement appears in and applies to manufacturer containers, not dispensed labels. So remember, the DEA schedule symbol is required on manufacturer containers, not on pharmacy dispensed prescription labels. Question 36. Before dispensing clozapine, which parties must the pharmacist verify are enrolled in the Clozapine REMS? Option A. Only the dispensing pharmacy must be enrolled in the Clozapine REMS before dispensing. Prescribers enrolled directly with the manufacturer's monitoring program, and patient A&C results are managed through the prescriber's office, removing those verification steps from the pharmacy. Option B. Clozapine requires only standard DEA controlled substance handling under Schedule IV regulations. The FDA has not mandated a REMS for antipsychotic medications, and no prescriber, patient, or pharmacy enrollment verification is required before dispensing. Option C. The prescriber, the patient, and the dispensing pharmacy must all be enrolled. The pharmacist must also verify the patient's A&C meets the required threshold before each dispense. The correct answer is C. The prescriber, the patient, and the dispensing pharmacy must all be enrolled. The pharmacist must also verify the patient's A&C meets the required threshold before each dispense. Here's why. The Clozapine REMS requires three-party enrollment. The prescribing physician must be certified. The patient must be enrolled and monitored. A&C monitoring is required because of clozapine's risk of life-threatening agranulocytosis, and the dispensing pharmacy must be certified. The pharmacist must confirm a current A&C result meets the minimum threshold before releasing each fill. Option A is wrong because Option A eliminates prescriber and patient verification from the pharmacist's REMS obligations. The Clozapine REMS requires the pharmacist to confirm all three parties, prescriber certification, patient enrollment, and pharmacy certification before each dispense. Manufacturer direct prescriber enrollment exists but does not remove the pharmacy's obligation to verify enrollment status before releasing medication. Option B is wrong because Option B incorrectly states clozapine has no REMS and misclassifies it as a controlled substance. The FDA mandated the clozapine REMS specifically because of the drug's risk of life-threatening agranulocytosis. Clozapine is not a controlled substance. Its stringent REMS controls arise from serious adverse event risk, not DEA schedule classification. Dispensing without REMS verification is a serious regulatory violation. So remember, Clozapine REMS requires three-way certification, prescriber enrolled, patient enrolled with qualifying A&C, and pharmacy certified before every single dispense. Question 37. Under the IPledge REMS for isotretinoin, what are the pharmacist's dispensing obligations? Option A. The pharmacist may dispense up to a 60-day supply of isotretinoin with prescriber-authorized refills. IPledge enrollment verification is required only at the initial dispense, and subsequent refills are released on the prescriber's authorization without requiring a new system authorization number. Option B, the pharmacist must dispense no more than a 30-day supply, no early fills, and must obtain a dispense authorization number from IPledge confirming REMS compliance before each dispense. Option C, IPledge requirements apply exclusively to female patients of childbearing potential. Male patients and patients who have completed sterilization procedures may receive isotretinoin prescriptions without REM system enrollment, authorization numbers, or periodic monitoring verification. The correct answer is B. The pharmacist must dispense no more than a 30-day supply, no early fills, and must obtain a dispense authorization number from IPledge confirming REMS compliance before each dispense. Here's why. Under IPledge, every isotretinoin dispense, regardless of patient sex, requires prior authorization from the IPledge system. The pharmacist must obtain a dispense authorization number before releasing the medication. No more than a 30-day supply may be dispensed, and early fills are prohibited. Option A is wrong because Option A states a 60-day supply limit and exempts refills from IPledge verification. Both are incorrect. IPledge restricts each individual dispense to a 30-day maximum, and every dispense, including refills, requires a separate dispense authorization number from the system. The program's risk mitigation requires monthly verification regardless of prior dispense history. Option C is wrong because Option C incorrectly excludes male patients from IPledge. Every patient receiving isotretinoin must be enrolled in the IPledge system, and every dispense requires a system authorization number regardless of patient sex. Male patients have different monitoring requirements than females of childbearing potential, but all patients are equally subject to the mandatory dispense authorization step. So remember, IPledge requires an authorization number before every dispense for all patients, regardless of gender. 30-day supply max, no early fills. Question 38. A community pharmacy compounds the same progesterone suppository batch weekly without individual patient prescriptions, anticipating demand. Under the FDCA, this practice most likely violates which principle? Option A. 503A compounders must compound based on individual patient-specific prescriptions and may not routinely compound in advance in quantities resembling manufacturing. Option B. The FDA does not regulate compounded preparations made from commercially available APIs, so no violation has occurred. Option C. 503A pharmacies may not use commercially available APIs. Only bulk active pharmaceutical ingredients are permitted. The correct answer is A. 503A compounders must compound based on individual patient-specific prescriptions and may not routinely compound in advance in quantities resembling manufacturing. Here's why. Under federal law, traditional compounding pharmacies must compound based on individual patient prescriptions. Limited anticipatory compounding is permitted for preparations based on a history of received prescriptions, but routinely batch compounding the same product weekly without patient-specific prescriptions crosses into manufacturing activity and exceeds 503A's scope. Option B is wrong because Option B incorrectly states the FDA has no jurisdiction over compounded preparations using commercially available APIs. The FDA's oversight of compounded drug preparations applies regardless of API source. The DQSA significantly expanded FDA oversight of pharmacy compounding. Option C is wrong because Option C incorrectly restricts 503A compounders from using commercially available APIs. 503A pharmacies may use commercially available APIs as starting materials. The restriction concerns finished drug products. 503A pharmacies cannot routinely compound essentially copy preparations of commercially available finished products. So remember, 503A compounding must be based on individual patient prescriptions. Batch compounding the same product weekly crosses into manufacturing. Question 39. A pharmacy suspects a received product may be suspect under the DSCSA. What is the required response? Option A. Continue dispensing the suspect product to maintain patient access while conducting an internal investigation. Under DSCSA, the quarantine obligation is triggered by confirmed illegitimacy rather than suspicion, so dispensing during an investigation does not violate the statute. Option B. Immediately quarantine the suspect product, investigate whether it is illegitimate, and if confirmed illegitimate, notify the FDA and immediate trading partner within 24 hours. Option C. Forward the suspect product to the FDA for laboratory analysis and await a formal FDA illegitimacy determination before quarantining or notifying trading partners. DSCSA requires FDA confirmation before dispensers must take any action on a suspect product. The correct answer is B. Immediately quarantine the suspect product. Investigate whether it is illegitimate, and if confirmed illegitimate, notify the FDA and immediate trading partner within 24 hours. Here's why. Under federal law, dispensers must quarantine suspect drug products immediately upon identification. Following quarantine, the dispenser must investigate whether the product is illegitimate. If confirmed or strongly suspected illegitimate, the dispenser must notify the FDA and the immediate trading partner within 24 hours. Option A is wrong because Option A misreads the trigger for DSCSA quarantine. Under federal law, the quarantine obligation is triggered by suspicion, not by confirmed illegitimacy. Dispensing a suspected product while conducting the investigation is exactly what the quarantine requirement is designed to prevent. Option C is wrong because Option C incorrectly places the investigation and response burden on the FDA. Under federal law, dispensers must independently investigate and quarantine suspect products pending their own investigation. DSCSA notification to the FDA and trading partner is required upon the dispenser's own determination of illegitimacy. The pharmacy cannot delegate the investigation to FDA or delay quarantine awaiting federal confirmation. So remember, a DSCSA suspect product must be quarantined immediately. If confirmed illegitimate, notify FDA and your trading partner within 24 hours. Question 40. A pharmacy receives a prescription drug shipment from a wholesale distributor. Under the DSCSA, which documents must accompany the shipment? Option A. A safety data sheet for each drug product in the shipment as required under OSHA's Hazard Communication Standard, because the DSCSA incorporated OSHA's chemical safety documentation requirements for all prescription drug transfers between registered trading partners. Option B, transaction information, TI, transaction history, TH, and transaction statement, TS, the T3 documents. Option C, a DEA Form 222 for each scheduled controlled substance in the shipment because the DSCSA created a unified federal supply chain accountability framework incorporating DEA ordering documentation requirements for all prescription drug transfers, including Schedule 3 through V. The correct answer is B, transaction information, TI, transaction history, TH, and transaction statement, TS, the T3 documents. Here's why. Under the DSCSA, each transfer of a prescription drug product must be accompanied by transaction information, product identifier, lot number, expiration date, quantity, sender and receiver names, transaction history, complete record of prior transactions, and transaction statement, the transferor's certification of legitimacy. These T3 documents establish the chain of custody required by the statute. Option A is wrong because Option A describes safety data sheets required under OSHA's HAZCOM standard for hazardous chemicals. SDS documents are entirely separate from DSCSA traceability documentation. DSCSA and OSHA HAZCOM are independent regulatory systems addressing different purposes. DSCSA does not incorporate OSHA chemical documentation requirements. Option C is wrong because Option C describes DEA Form 222 required for Schedule 1 and 2 controlled substance ordering under Federal Regulations 1305, DEA Form 222, and DSCSA T3 documents are separate systems serving distinct purposes. Form 222 tracks Schedule 1-2 ordering, DSCSA T3 documents track all prescription drugs through the supply chain. The two systems are not unified, and Form 222 does not satisfy DSCSA documentation requirements. So remember, every drug shipment must be accompanied by the T3 documents: transaction information, transaction history, and transaction statement. Question 41. A pharmacist receives a prescription for sildenafil 100 milligrams for pulmonary arterial hypertension, PAH. Sildenafil is FDA approved at 20 milligrams, Revatio for PAH, and 25 to 100 milligrams, Viagra, for erectile dysfunction. Which statement is most accurate? Option A, dispensing sildenafil 100 milligrams for PAH constitutes misbranding under federal law because the drug's FDA-approved labeling specifies dosing for erectile dysfunction. Filling a prescription at the full 100 milligrams dose for an unapproved indication violates the FDA labeling requirements applicable at the pharmacy level. Option B, the pharmacist must contact the FDA to verify that an off-label use approval has been issued for PAH before dispensing sildenafil 100 milligrams, because off-label dispensing without documented FDA authorization constitutes unlicensed drug promotion under FDCA misbranding provisions. Option C, a pharmacist may lawfully dispense sildenafil 100 milligrams for PAH when prescribed by an authorized practitioner for a legitimate medical purpose, because pharmacists may dispense drugs for off-label uses. The correct answer is C. A pharmacist may lawfully dispense sildenafil 100 milligrams for PAH when prescribed by an authorized practitioner for a legitimate medical purpose, because pharmacists may dispense drugs for off-label uses. Here's why. The FDA prohibits manufacturers from promoting drugs for off-label uses, but this restriction applies to manufacturers, not prescribers or pharmacists. Pharmacists may lawfully dispense drugs prescribed by licensed practitioners for legitimate off-label medical purposes. No FDA clearance is required for each off-label dispense. Option A is wrong because Option A misapplies the misbranding concept to pharmacist dispensing. Misbranding under federal law applies to manufacturer labeling. Pharmacists dispensing drugs prescribed by licensed practitioners for off-label uses are not creating manufacturer labeling. They are filling valid prescriptions. Off-label prescribing is a legal and widely practiced clinical activity not governed by misbranding provisions. Option B is wrong because Option B invents an FDA off-label approval process that does not exist for individual prescriptions. Off-label prescribing requires no FDA pre-authorization. The FDA regulates manufacturer promotion of specific uses. It does not restrict or authorize individual clinical prescribing decisions. No pharmacist verification with FDA is required before dispensing a drug for an off-label purpose. So remember, off-label dispensing is legal. The FDA restricts manufacturer promotion, not the pharmacist's ability to dispense a valid prescription. Question 42. Under the Controlled Substances Act, which set of criteria defines a Schedule I controlled substance? Option A, accepted medical use with severe restrictions, moderate to high potential for abuse, and may lead to severe physical dependence. Option B, high potential for abuse, currently accepted medical use in treatment in the U.S., and may lead to severe physical or psychological dependence. Option C, no currently accepted medical use in treatment in the U.S., high potential for abuse, and lack of accepted safety even under medical supervision. The correct answer is C, no currently accepted medical use in treatment in the U.S., high potential for abuse, and lack of accepted safety even under medical supervision. Here's why. Under federal law, a Schedule I substance has 3 defining characteristics: no currently accepted medical use in the U.S., high potential for abuse, and lack of accepted safety under medical supervision. These collectively explain why Schedule I drugs cannot be prescribed or dispensed at retail pharmacies. Option A is wrong because Option B describes Schedule III. Under federal law, Schedule III substances have currently accepted medical use and less potential for abuse than Schedule I or II. The presence of accepted medical use is the key feature placing a substance below Schedule I. Option B is wrong because Option B describes Schedule II. Under federal law, Schedule II substances have high potential for abuse and currently accepted medical use with severe restrictions. Schedule I specifically lacks any accepted medical use, the critical distinction separating it from Schedule II. So remember, Schedule I requires all 3: no accepted medical use, high abuse potential, and lack of accepted safety under supervision. Question 43. A physician prescribes a compounded testosterone preparation for a patient with documented hypogonadism. Under federal law, which statement is most accurate about a 503A pharmacy dispensing this? Option A. A 503A pharmacy may dispense a compounded testosterone preparation based on a valid patient-specific prescription for a legitimate medical purpose, provided it meets 503A requirements. Option B. A 503A pharmacy may not dispense any testosterone preparation because testosterone is an anabolic steroid categorically prohibited from compounding. Option C. Compounding testosterone is permissible without a prescription because Schedule III scheduling imposes fewer restrictions on compounding. The correct answer is A. A 503A pharmacy may dispense a compounded testosterone preparation based on a valid patient-specific prescription for a legitimate medical purpose, provided it meets 503A requirements. Here's why. Under federal law, a traditional compounding pharmacy may compound testosterone for individual patients with valid prescriptions for legitimate medical purposes. Testosterone compounding is not categorically prohibited. A prescriber may have valid clinical reasons for a compounded formulation, for example, specific concentration or vehicle not commercially available. Option B is wrong because Option B overstates the restriction. While FDA has placed some testosterone products on lists of concern for bulk compounding resembling manufacturing, testosterone is not categorically prohibited from patient-specific 503A compounding based on a valid individual prescription. Option C is wrong because Option C incorrectly suggests Schedule 3 scheduling reduces prescription requirements for compounding. Schedule 3 status affects refill rules and verbal prescription authorization. It does not eliminate the patient-specific prescription requirement for 503A compounding. So remember, 503A pharmacies can compound testosterone for patient-specific prescriptions with documented clinical need, even when commercial products exist. Question 44. The TERF REMS Access Program applies to which medications, and what must the pharmacist verify before dispensing? Option A, long-acting insulin analogs, including insulin glargine and insulin degludec. The pharmacist must verify that the patient is enrolled in a diabetes disease management program and that the prescriber holds certification in insulin therapy management before each dispense. Option B, extended-release opioid products such as oxycodone ER and morphine ER. The opioid analgesic REMS for extended-release and long-acting opioids requires the pharmacy to verify the patient completed a mandatory counseling program and that the prescriber holds certification in pain management before each dispense. Option C, transmucosal immediate-release fentanyl products such as Actique and Subsys. Confirm the prescriber, patient, and pharmacy are all enrolled in TERF REMS and the patient is opioid tolerant. The correct answer is C. Transmucosal immediate-release fentanyl products such as Actique and Subsys. Confirm the prescriber, patient, and pharmacy are all enrolled in TERF REMS and the patient is opioid tolerant. Here's why. TERF REMS access covers transmucosal immediate-release fentanyl products, buccal, sublingual, and intranasal formulations for breakthrough cancer pain in opioid-tolerant patients. Before dispensing, the pharmacist must confirm 1. Prescriber enrolled, 2. Patient enrolled and opioid tolerant, and 3. Pharmacy certified. These products carry extreme risk of fatal respiratory depression in non-tolerant patients. Option A is wrong because Option A describes a fictional insulin REMS framework. No FDA-mandated REMS requires diabetes management program enrollment for long-acting insulin products. TERF REMS covers transmucosal, immediate-release fentanyl products specifically. It has no application to insulin or other non-opioid medications. Option B is wrong because Option B describes the opioid analgesic REMS for extended release and long-acting opioids, which is a real but different REMS from TERF. The opioid analgesic REMS focuses on prescriber, education, and patient counseling materials. It does not require the three-party enrollment verification that TIRF mandates. TIRF specifically covers transmucosal, immediate-release fentanyl, and requires prescriber, patient, and pharmacy enrollment confirmation before each dispense. So remember, TIRF REMS covers transmucosal fentanyl products. prescriber, patient, and pharmacy must all be enrolled, and opioid tolerance must be documented. Question 45. Under the Hatch-Waxman Act, what is the primary purpose of an abbreviated new drug application, ANDA? Option A, to seek FDA approval for a generic drug by demonstrating bioequivalence to an already approved reference-listed drug without repeating full clinical efficacy trials. Option B, to seek FDA approval for a biosimilar by demonstrating similarity to a reference biologic in structure and function. Option C, to seek FDA approval for a new chemical entity by demonstrating a unique mechanism of action in Phase 3 clinical trials. The correct answer is A, to seek FDA approval for a generic drug by demonstrating bioequivalence to an already approved reference-listed drug without repeating full clinical efficacy trials. Here's why. The Hatch-Waxman Act, 1984, Public Law 98, 417, created the ANDA pathway, allowing generic manufacturers to obtain FDA approval by demonstrating bioequivalence to the brand name reference listed drug, RLD. Because the reference drug's safety and efficacy are already established, the generic applicant need not repeat clinical trials. Bioequivalence data is sufficient. Option B is wrong because Option B describes the biosimilar pathway under the BPCIA using an abbreviated BLA. Biosimilars and generics follow different approval pathways. The ANDA pathway is for small molecule generic drugs listed in the FDA's Orange Book. Option C is wrong because Option C describes a full NDA for a new molecular entity under federal law. New chemical entities require complete safety and efficacy data from clinical trials. The ANDA's defining characteristic is that it substitutes bioequivalence data for clinical trial data. So remember, the ANDA pathway lets generics skip clinical trials by demonstrating bioequivalence to the reference-listed drug. Question 46. A pharmacist's prospective DUR reveals a new warfarin prescription for a patient already taking fluconazole. What is the most appropriate action? Option A, dispense both warfarin and fluconazole as prescribed, documenting the identified drug interaction in the patient's pharmacy profile. OBRA 90's prospective DUR obligation is satisfied by identifying and recording the interaction, not by withholding or delaying dispensing. Option B, substitute warfarin with apixaban to eliminate the CYP 2C9 interaction, because the pharmacist's independent therapeutic judgment authority under drug therapy management principles permits substitution of a safer anticoagulant when a dangerous drug interaction is identified. Option C, contact the prescriber before dispensing to discuss the clinically significant interaction, because fluconazole inhibits CYP2C9 and substantially increases warfarin levels and bleeding risk. The correct answer is C. Contact the prescriber before dispensing to discuss the clinically significant interaction, because fluconazole inhibits CYP2C9 and substantially increases warfarin levels and bleeding risk. Here's why. Fluconazole is a potent CYP2C9 inhibitor that significantly raises warfarin concentrations and INR, substantially increasing hemorrhage risk. OBRA 90's prospective DUR obligation requires acting on clinically significant interactions. However, this combination is not an absolute contraindication. Prescribers may use both drugs with enhanced monitoring. The pharmacist must contact the prescriber before dispensing. Option A is wrong because Option A describes documentation without prescriber notification. OBRA 90's prospective DUR obligation is not satisfied by merely noting an interaction and proceeding. A clinically significant interaction, especially one with serious hemorrhage risk, requires pharmacist action before dispensing, specifically contacting the prescriber to discuss the clinical concern. Option B is wrong because option B proposes unilateral anticoagulant substitution. Pharmacists may not independently substitute one anticoagulant for another without explicit prescriber authorization. Anticoagulant selection involves complex clinical decisions across indication, renal function, bleeding history, and monitoring that are reserved for the prescriber. No general therapeutic judgment authority permits changing anticoagulant class without prescriber direction. So remember, fluconazole inhibits CYP2C9 and substantially raises warfarin levels. This is not an absolute contraindication, but you must contact the prescriber before dispensing. Question 47. Under DEA scheduling, which classification applies to tramadol? Option A, Schedule 2, due to its opioid receptor activity. Option B, tramadol is not a federally scheduled controlled substance. It is only regulated at the state level. Option C, Schedule IV, as classified by the DEA in 2014 based on evidence of abuse, misuse, and diversion. The correct answer is C, Schedule IV, as classified by the DEA in 2014 based on evidence of abuse, misuse, and diversion. Here's why. The DEA classified tramadol as Schedule 4 effective August 18, 2014, following evidence of increasing abuse, misuse, diversion, and dependence. As a Schedule IV substance, tramadol is subject to the 5-refill 6-month rule under federal regulations. This is a high-yield trap topic because tramadol's scheduling is frequently underappreciated. Option A is wrong because Option A assigns tramadol to Schedule 2. Schedule 2 is reserved for substances with high abuse potential and severe dependence risk. Tramadol's lower dependence profile led the DEA to schedule it at the lower Schedule IV level. Option B is wrong because Option B incorrectly states tramadol is not federally scheduled. The DEA's 2014 final rule placed tramadol in Schedule No. 4 under federal law. Treating tramadol as a non-controlled substance creates significant dispensing and record-keeping compliance gaps. So remember, tramadol is Schedule 9-4 as of 2014, 5 refills within 6 months, just like other Schedule IV drugs. Question 48. A nurse practitioner with full prescriptive authority in her state and a valid DEA registration issues a Schedule 2 oxycodone prescription. Under federal DEA law, which statement is most accurate? Option A. Nurse practitioners may never prescribe Schedule 2 controlled substances under federal law regardless of state authority. Option B. The prescription requires a co-signature from a collaborating physician to be valid under federal DEA regulations. Option C. The prescription is valid under federal law. An NP with a valid DEA registration prescribing within their state authorized scope may issue Schedule 2 prescriptions. The correct answer is C. The prescription is valid under federal law. An NP with a valid DEA registration prescribing within their state authorized scope may issue Schedule 2 prescriptions. Here's why. Under the CSA, prescribing authority for controlled substances is granted to practitioners authorized under applicable state law who hold valid DEA registrations. An NP with full prescriptive authority, including Schedule 2, under state law and a valid DEA registration is a lawfully authorized prescriber. Federal law defers to state-defined scope of practice in determining practitioner eligibility. Option A is wrong because Option A reflects an outdated understanding of NP prescriptive authority. Federal law does not categorically prohibit NPs from prescribing Schedule II substances. It defers to state law. In states granting full prescriptive authority, an NP with a DEA registration may prescribe any schedule within their clinical scope. Option B is wrong because Option B invents a federal co-signature requirement. No DEA regulation requires physician co-signature for independently authorized NPs. The DEA registration itself is the federal authorization. So remember, an NP with full prescriptive authority and a valid DEA registration can prescribe Schedule II. Federal law defers to the state-defined scope of practice. Question 49. Which labeling element is required on all OTC drug product labels under FDA regulations? Option A, a drug facts panel including active ingredients, purpose, uses, warnings, directions, and inactive ingredients. Option B, a boxed warning on any OTC product containing acetaminophen above 325 milligrams per dosage unit, as required by FDA guidance for products with hepatotoxicity risk. The boxed warning format is required for OTC acetaminophen products to alert consumers and caregivers. Option C, an FDA-approved medication guide for each OTC drug product, providing patient safety information on adverse effects, contraindications, and drug interactions in a format separate from the product label and dispensed with every OTC purchase. The correct answer is A, a drug facts panel, including active ingredients, purpose, uses, warnings, directions, and inactive ingredients. Here's why. Under federal regulations, FDA regulations require all OTC drug products to bear a standardized drug facts panel containing active ingredients and amounts, purpose, uses, warnings, including when to stop use and when to see a doctor, directions, other information, and inactive ingredients. Option B is wrong because Option B describes a boxed warning for OTC acetaminophen. Boxed warnings under federal regulations are a prescription drug labeling format, not an OTC requirement. OTC acetaminophen products carry liver damage warnings within the drug facts panel, but the box warning format is reserved for prescription drug labeling and does not apply to OTC products. Option C is wrong because Option C describes FDA medication guides under federal regulations, which are required for specific prescription drugs under REMS or risk management programs. Medication guides are a prescription drug tool. They are not required for OTC products. OTC drug labeling is governed by the Drug Facts Panel Regulation, an entirely separate framework from the MedGuide system. So remember, every OTC drug product must have a Drug Facts Panel. Medication guides are for specific prescription drugs only. Question 50. A pharmacy receives notification of an FDA class I recall affecting a drug lot in its dispensing inventory. What are the pharmacist's obligations? Option A. Immediately remove the recalled product from dispensing inventory, follow the recall notification instructions, and notify patients who received the recalled lot when feasible. Option B. A pharmacy's class. I recall response is limited to notifying patients who purchased the affected lot within the prior 30 days. The manufacturer and wholesale distributor bear primary responsibility for all product retrieval, lot quarantine, and regulatory reporting to the FDA. Option C. A pharmacy may continue dispensing a Class 1 recalled product for patients with critical therapeutic needs while placing a replacement order, provided the pharmacist documents the clinical necessity and informs each patient of the recall status at the time of dispensing. The correct answer is A. Immediately remove the recalled product from dispensing inventory, follow the recall notification instructions, and notify patients who received the recalled lot when feasible. Here's why. A Class I recall indicates reasonable probability that the recalled product will cause serious adverse health consequences or death. Pharmacies must immediately quarantine and remove the affected lot from dispensing inventory. Depending on the recall strategy, the pharmacy may also be obligated to contact patients who received the recalled lot. Option B is wrong because Option B incorrectly limits pharmacy Class 1 obligations to patient notification and shifts quarantine responsibility to upstream trading partners. FDA recall guidance applies throughout the distribution chain. Pharmacies must independently quarantine affected product and participate in recall execution. They cannot discharge Class 1 obligations by capping notification at 30 days and deferring quarantine to manufacturers or distributors. Option C is wrong because Option C creates a clinical necessity exception that does not exist for Class 1 recalls. Class 1 indicates reasonable probability of serious adverse health consequences or death. No medical necessity exception permits continued dispensing. When a Class 1 recall affects a critical medication, the pharmacist must immediately quarantine the product and work with prescribers to source unaffected alternatives. So remember, a Class Y recall means a reasonable probability of serious harm. Immediately quarantine and notify affected patients.